NT was separately brought in the room.
And when was NT separately brought into the room? Was that before or after the mother read her statement?
Before.
Okay, and what happened with NT in parenting time?
She entered the room, turned her back to her father, crossed her arms, and refused to engage in any conversation. Correct. I attempted to ask how her school year had been. It had been a while since I'd seen them. And she kind of did one of these and squinted her eyes and said, "I'm not talking to you."
She said that to you?
Correct.
Did she talk at all during the rest of that parenting time session?
I made a comment about, "Wow, I'm not sure what I've done to upset you. I haven't seen you in the better part of a year. And I'm sure your mom wouldn't want you speaking to adults this way." And she just repeated, "I'm not speaking to you."
Did she speak to Art Gallagher that day?
No.
Did she speak to Omar Simone?
No.
Did she speak to the judge that day, to the best of your knowledge?
No.
Okay, what happened after that completely failed parenting time?
To the best of my recollection, that's when
You and the judge left the room?
Correct.
Okay. Were you part of the conversation that the judge had with counsel concerning a statement for the mother to read?
No.
Okay. When you go back into the jury room on the 24th, what occurs?
Both parents are there. All three children are there. Judge Art Gallagher, Bill Lancet, Mabel Bossery, and myself. Mother proceeds to read a statement from a piece of paper to the children to encourage them to engage with their father.
And what did this statement say?
Something to the effect of, "I want you to have a relationship with your dad. He loves you. He's not going to hurt you." Just a real brief statement.
What was the mother's affect when she was doing this?
Very flat, almost robotic.
Okay. Did the mother add anything to the statement?
She did. She began to speak in Hebrew.
Okay. Do you know what was said in Hebrew?
I do not.
Okay. Once that occurred, how did parenting time go?
It did not go.
So even though RT had said, "I always listen to my mother," and even though the mother has come in and, whether flatly or not, instructed him to participate in parenting time, the children are still refusing to do so.
Correct.
Okay, was Judge Gorcyca still in the room at that time?
I don't recall
At the
exactly
time
when
of
she
the
left.
reading of the statement?
At the time of the reading of the statement, yes.
Okay. And after that, what's the next thing you remember?
I remember saying to RT, "Your mom just told you she wants you to have some time with your dad and a relationship with your dad, and you said you always listen to your mom, and you always do what your mom says." And he said, "Well, I can make my own decisions."
So even though he said, "I always listen to my mom," he was just not going to be participating in parenting time?
Correct.
Did you get the impression that there was anything that you could do at that time, at that point, to improve parenting time that day?
No.
Okay. What's the next thing you remember concerning the Simone case?
That after the children refused again to exercise any time with their dad, the judge called everybody back into the hearing room.
And the contempt hearing was held?
I think attorneys were appointed first and given a chance to meet with their clients.
Okay, but you did not meet with the clients at the time?
No.
Okay, so the next thing that you're involved in is a contempt hearing, correct?
Correct.
Okay. How long have you been doing family counselor work in Judge Gorcyca's court?
Since 2009.
Do you have an opinion of Judge Gorcyca's demeanor from the bench as a general rule?
She's extremely patient. She's very positive in trying to get our families to give each other a fresh start and move forward in a positive way for the children.
Have you ever seen Judge Gorcyca use stern language with people?
Only on this occasion.
Okay, so have you ever seen Judge Gorcyca get frustrated or exasperated on the record?
With this case, yes.
Okay, this case was a particular thorn in her side, or?
I think she was just exasperated that we had run out of options and other supports to try to help this family heal.
Okay. Do you have any experience with whether Judge Gorcyca talks with her hands?
I'm sorry, talks with what?
Her hands.
With her hands.
She does all the time.
Okay. Do you have any idea whether she even knows she's doing it?
Objection, calls for speculation.
Do you have any experience with Mandy's Place or Children's Village?
No.
Give me a second if you would, please. I think we're all set then.
All right, thank you, Cross.
No question.
All right, thank you. Mrs. You may step down. Next witness.
Brother, we would recall Judge Gorcyca.
All right. Judge Gorcyca, although we did this yesterday, we'll do it one more time. So true, let it put yourself, you got it.
I do.
All right, thank you. Have a seat. And you may proceed.
All right, thank you. Judge Gorcyca, good morning.
Good morning.
All right. I think yesterday we established the fact that you've been a lawyer for some 23 years or so,
Yes.
is that right? Correct?
Yes,
Started your, at least your legal career formally in the Oakland County Prosecutor's Office,
I did.
and then you were elected to the Oakland County Circuit Court bench in November of 2008, correct?
Yes.
Took the bench in January of 2009.
Yes.
Initially, you were assigned to what we call the General Jurisdiction Court, is that true?
Yes.
Tell us about that and how it is that you came to be assigned to the family court division.
All right, when I won, there were two openings, and the chief judge was able to let the person who had the most votes pick which spot. So I was able to pick which one, and after much deliberation, I actually asked for an extension because I couldn't decide which one I liked. I had a close friend in family court who loved it and thought I should do it. Then I had a judge who said I shouldn't do it, and I really flip-flopped, and I ended up picking general jurisdiction.
All right. And how long were you in the General Jurisdiction Division of the Oakland County Circuit Court then?
1 year.
Okay. And then you moved to the Family Court Division?
Yes.
And approximately when was that?
That was January 1st, 2010.
All right. And when was it that you first had contact or were assigned the Simone case?
Well, it would have been on my docket when I started, January 2nd, 2010, but I didn't have contact with it till they had their first court appearance.
All right. So you inherited your docket from which judge?
Judge Martha Anderson.
And you mentioned that your first contact with the Simone case was when the parties came before you for some type of hearing, is that right?
Yes.
Okay. And you recall that first contact?
One of the first contacts was Dad was alleging in 2010 parental alienation, among other things.
All right. Was there also an issue about parenting time?
Yes.
Okay. And we've heard a lot of testimony about parenting time. Was parenting time, kind of a paramount issue that seemed to be recurring over and over again in the Simone case?
Yes.
You've handled probably more than 46,000 cases, is that
Yes.
true?
Yes.
Where would you put the Simone case in terms of the difficult cases you've handled over the course of your career?
Right at the top.
We heard some testimony before about the number of motions. Can you tell us, over the course of the time that you were involved in the case, how many different hearings you had in the Simone case?
I would say there were, looking at the court docket, 38 hearings to the date of the June 24th. I didn't do all of them. A couple of them were out when I had breast cancer. Judge Jack McDonald, retired judge, came in and did the trial. Judge Matthews handled the parenting time violation. Judge Hallmark had handled it in my absence as well. So other than those, I did all of them.
How many different orders were entered in the case?
I think like 77 at least. I'm guessing about that amount. There was a lot.
All right. And the volume of pleadings and things that were filed, could you describe that for us, please?
Yes, if it was sitting here, it would be completely blocking the view. It took 2 clerks to carry them all. They were extremely large and lengthy.
Right.
In fact, I comment on the video that I don't know how many trees have been killed over this case.
And if I'm looking at your hand gesture correctly, you're gesturing in terms of the stack, if you will, of pleadings, at least a couple of feet, maybe as tall as 3 feet high.
Longer than what you're doing.
All I can say is that just the exhibits from the case took 2 banker's boxes. So, all right, go ahead.
All right, thank you, Ron. That's a good clarification. Judge Gorcyca, again, I don't want to repeat everything that we've already done, but obviously there were a number of different attempts over time to enforce your parenting time orders and to have meaningful parenting time for the father. Isn't that true?
Yes.
Could you describe for us in a summary fashion what those different attempts and efforts were?
Unsupervised, supervised, therapeutic supervision, therapists, doctors, counselors, friends, libraries, dogs, no dogs, mother's house, dad's house, mother's friend's house, different restaurants, different type of fun activities, zap zone, bowling, different types of restaurants, different types of treats, anything that the mother and father could think of, that the guardian could think of, that I could think of, that the therapist could think of, that the supervisors could think of, we tried to implement to get it done.
Okay. And this occurred literally over a period of years, did it not?
Yes.
Was it often the case that it was actually the parties who their lawyers who were coming to you with thoughts and ideas about orders you should enter regarding parenting time?
Yes,
But you also indicated you had some of your own thoughts and ideas. Is that true?
I did.
All right. And is it fair to say that over this 4.5, 5-year period of time, in essence, nothing really worked?
Nothing was working.
Okay. And the individuals, the parties were coming back to you time and time again to hopefully enforce this parenting time order, right?
Yes,
And these were orders that you had issued, true?
yes,
And you had expected and anticipated, just as you do in any other case, when you issue an order, you expect and anticipate and want it to be followed, right?
absolutely.
Let's fast forward a bit. We talked about the history a bit. I want to take you back to August the 21st of 2014. You remember that day?
I do.
Was that the day that you actually first had contact with the Simone children directly?
It was.
And how did you have contact with the Simone children directly on that day?
Mom and Dad, after consultation with their lawyers and the guardian, decided that something needed to be done. And they wanted parenting time was going to start going to occur in my courthouse, in my jury room.
Let me stop you right there. Had you ever, up to this point in time, had parenting time in your jury?
Never.
And were you agreeable to having it there?
You know, I was. They thought it was gonna work if it happened there, and if it didn't work, I could do something about it. So it was twofold. So it would get it done.
Okay. And so this was the idea of the parties, right, through their lawyers?
Yes.
And you agreed to it even though you'd never done that before, right? Okay. And so this was the day that parenting time was supposed to occur in your jury room, right?
Yes.
All right. And I interrupted you. Please go ahead. How did you first encounter the Simone children that day?
Approximately maybe 10:30 in the morning, Mr. Lancet came into court when I was doing bench warrant arraignments and said, "Judge is not working. You need to bring deputies up. The kids are refusing."
And did you do that?
So I said, "Bring Mom in here."
And what happened?
I said to Mom on the record with Mr. Lancet, there were no other lawyers, and I said, Mom, you don't get to ask your kids if they want parenting time, because that was what was being relayed to me. Mom says, "Kids, do you want to go have parenting time? Do you want to go in the jury room?" I said, "Mom, you're not asking them. You're telling them. Those kids are going into my jury room right now unless you want deputies involved in their lives." And so we had a short discussion on the record, and Bill thought he could get it done and it would work, and then eventually it wasn't working and deputies came up.
Okay. When you said Bill thought it could work, you meant Mr. Lancet, of course,
Yes.
right? All right. And so deputies came up in an effort or attempt to convince the children to go and have parenting time in your jury room, as was agreed to, right?
Yes.
Objection speculative.
Now, I'm asking overall, thank you. Did there come a point in time when you asked someone from the prosecutor's office to become involved?
Yes.
And who did you ask?
So Lisa Harris, who testified yesterday, she's amazing with children. She has had a lot of experience with kids. She has done wonders in my courtroom with other types of cases. And so I asked my staff to call her to see if she would even, number one, available, and number two, willing, because she has nothing to do with custody cases.
And she came up, did she not?
She did.
And to the best of your knowledge, she attempted to help the situation?
No, she did. I watched. I walked at some point. I walked and opened the door a little crack, or I watched through the windows. I saw all the efforts she did. I heard all the efforts she did. I heard everything the deputies were saying. I heard what Mr. Lancet was saying. I heard what Mom was doing in response. I heard what the children said, which there was nothing. And I saw what they were doing to armed deputies, to a prosecutor, to anybody involved. They did not care that they were violating the court orders, and they were not about to get out of their chairs.
All right. And I think we've already heard the testimony that the children were there not only seated in their chairs, but they were locked arm in arm. Is that true?
That is true.
Did there come a point in time when you personally got involved trying to convince the children to follow the order that had been entered?
After I wanted to put on the record, because I thought it was only fair that the other side was going to be able to hear everything I was saying. So I called Mom and Mr. Lancet, and Ms. Harris came into the courtroom, and we put it on the record, everything that was occurring. That Mom was unable to assist these children. The children wouldn't listen to deputies. The children wouldn't listen to the prosecutor. They were being told, you are going to go to Children's Village if you don't get out of your chairs and have parenting times.
Who told them that?
Lisa Harris, Deputy Maloney, maybe another deputy, Bill Lancet. Several adults told them that, and nothing was getting them out of their chairs. When all they had to do was go into my jury room, where Art Gallagher, who they had known for at least over a year, and their father, who they'd known for all their life, was waiting.
All right. And so, did you then personally get involved going outside the courtroom to talk to the children?
Well, I did, but not until Ms. Harris suggested I hold them in contempt. Ms. Harris said, Judge, this is...
Objection, are you saying?
All right, I think we've already established.
It's admitted in the transcript on August 21st. So, overall.
Thank you, Ron.
So Ms. Harris suggested that it was ridiculous. And she said, Judge, I think you need to appoint these children lawyers. Let's have a hearing for contempt. We can do it this afternoon at that. And Mr. Lancet says, Judge, basically nobody wants these kids to go to Children's Village. Let's just give it one more shot. So I went out there to give it a shot.
Well, let me stop right there. You decided not to adopt Ms. Harris's suggestion.
Not at that point in August, when the kids were 1 year younger, I did not.
And why not?
Their guardian is saying, Judge, let's just give it one more try. Let's just give it one more try. Nobody wanted those children to go to Children's Village.
But you've been trying for days, and months, and years, right?
Years.
But you were going to give it another try.
One more try.
All right. So you go outside.
I went out there and I spoke directly to those children, and I told them to get up and get into parenting time.
And did that have any effect or impact on them?
Eventually, it was well over, I'm going to go with like 11:45 when I went out there to talk to them. And I think they were supposed to be there at 9 a.m. So they were sitting out there for at least over an hour, maybe two. Eventually, it worked. Tracy Steve came. Tracy Steve offered assistance, and eventually it worked. I mean, they went into the court. They went into my jury room, but they had no participation in parenting time at all.
Okay. We just heard the testimony of
Yes.
Tracy Steve. Were you present during the interactions by the children with their father and Mr. Gallagher?
No.
All right. When did you then hear about what was happening in the jury room, and what, if anything, did you do?
At that point, I didn't do anything. I don't know when I heard about it. And then the next day they came to my jury room for parenting time. And I don't hear how things go unless one of the parties bring it to my attention, or if I'm right there and I see it.
All right. But you came to learn, did you not, that parenting time on both on that August date and the following date was not successful, right?
Correct.
Okay. But you didn't hold the children in contempt, did you?
No.
Did you continue with efforts through working with the lawyers to try to, again, find a way to make parenting time work?
Yes.
What did you do?
Well, eventually, Dad's lawyer kept bringing motions for show cause for Mom being in contempt. And so either we would try to work it out for different sanctions or different ideas, which would include no electronics for the children, nothing fun for the children if they didn't participate in parenting time. And there were times where the little girl would curl up on a ball and not even move, and not get out. They wouldn't get out of the car. They wouldn't eat food. What he was, which she should settle, that she could volunteer. We have a lovely animal control. Oakland County has a great animal control. He says, why don't you have her go over there? And so Mr. Brassard goes, let me talk to her. I go, you have to call Miss Middleditch. So I'm not agreeing to anything until Miss Middleditch would agree. Ex-party, I'm not doing ex-party. And so he talks to his client. Apparently he called Miss Middleditch, and he came back and said, Miss Middleditch agrees. I'm like, write it up, or so that was the deal. So the mom went downstairs for how long, I don't have any idea. I'm assuming till noon, because that was the agreement. And then I'm assuming she did her 2 days at the animal control.
All right. And that was for contempt,
That
for
was-
unparenting time.
Well, it was something mom agreed to the day earlier instead of going through a show cause.
Show cause hearing on the parenting time.
Yes.
Fair to comply with the parenting time.
Yes.
All right,
And
great.
that was also the day mom agreed on their own to take the children to Children's Village. So mom's
Let
lawyer.
me stop you there. What was the purpose?
I just wanted to ask about, go ahead, thank you.
Okay, all right.
Thank you.
Thank you.
I didn't want to steal away from your direct note.
You could
Okay, go ahead.
do as much as you want. Thank you. All right. You said the other part of the order, or another part of the order, had to do with the touring of Children's Village. Is that right?
Yes.
Talk about that, and why was that important if it was?
All right. Well, in August, people were adults, people in authority were telling those children, if you continue this, if you don't do this, you're going to be living in Children's Village. So that was August the previous year. Now this is April, and it was put on the record that mom had to take the kids to tour Children's Village, and not by me. That was something either mom brought up, her attorney brought up, the guardian brought up, dad or dad's lawyer, but all 5 of them agreed to that. So that was a tool that was in my toolbox that, quite frankly, had been in there for years, but nobody even suggested it until August of 2014.
Okay. And when you say it wasn't brought up by you, again, it was brought up by counsel for the parties. They had suggested this as part of a stipulated order, and you, of course, agreed with that and executed the order. True?
Yes.
All right. And presumably, your intent, at least with regard to signing off on that order, was once again you wanted to let the children know about potential consequences that might occur if they fail to follow your order.
Absolutely, and they should see where they would be living.
Do you know if that tour ever occurred?
I don't have any idea to this day if it did or not.
All right. Let's move forward then, if we can, to the date of June the 24th of 2015. Certainly remember that, right?
Yes.
And on that particular day, once again, the parties had agreed to have parenting time in your jury room, right?
Yes.
Just as they had before in August of 2014?
Yes.
Okay. And once again, this was the idea of counsel for the parties and the parties themselves. This wasn't necessarily your idea,
It
right?
was not my idea. It was something stipulated to.
Okay. But once again, you thought perhaps this might work, and you were willing to go along with it.
I was hopeful it would work.
Okay. And so, what happened on June the 24th?
It didn't work at all.
Okay. Again, I don't know that you need to go back through it in detail because you already have, but can you just summarize for us what happened when the children arrived, the attempts, and then what you ultimately decided to do?
All right, the middle child would have nothing to do with it. He was in my jury room first, and he was crying. He actually wasn't crying. He had his head between his legs, and was, I don't know even what you would call that. I have never seen it before. I haven't seen it since. And so I told him to knock it off and to sit up and to knock all of this off. It was too much. It was too long, and it was ridiculous.
And did that have an effect or impact on the middle child?
Basically, it didn't. He just stared at me.
And there were other attempts to bring other children into the room to have parenting time, and those were unsuccessful, right?
Yes,
And Ms. Steve described that in some detail. You were there for part of that, is that true?
I was.
All right. Eventually, you decided, did you not, to try and take the bull by the horns and prepare a statement for Mom to read?
Yes.
Why did you decide to do that?
Well, through the years of allegations from Dad's lawyer, from allegations in the GAL's, from the GAL's report, from therapists, that Mom was complicit, that Mom wasn't doing all Mom could do, that all Mom should do to get this parenting time done. So I thought, I'm going to use my words, because kids don't rule, shouldn't rule any house. They're kids. Kids don't rule the court, and kids have to follow court orders. So I thought using the words that I would use, that I do use, would help coming from Mom's mouth. So I wrote up a statement with the help of Mr. Bossary and Ms. Miladich, who agreed, and she agreed, so she read it to them. And it didn't help either.
But this was with everyone's concurrence, is that right?
Of course.
And you tried to make the message a stern one
Yes.
and a direct one,
Yes.
leaving no doubt as to the mom's feelings or view as to what the children should do.
Correct.
You read the statement, right?
Yes.
And in fact, I think we saw in the hearing in the video, you even complimented Mom for at least doing that, right?
Yes.
Maybe too little too late, I think were your words?
Yes.
But she at least did what you asked.
Correct.
And that had no effect or impact.
It did not.
So what
Well,
did you...
it might have for a minute on the two, the middle and the younger one.
Okay. So what did you decide to do?
I said, enough's enough. Enough was enough. I had taken 5.5 years to do something, and I'm following what I say, kids, this is it. This is it. I'm pointing you lawyers. We're going to have a contempt hearing. And the parents were there, and I was hopeful that 3 experienced lawyers would be able to, independent experienced lawyers would be able to make a difference to these children, and that I would never see them again. And like, not in a bad way, in a no offense way, but that if I don't see children, if I don't see parents in a divorce case, most divorce files are this thick. Those are the successful ones.
This thick meaning about an inch or less?
That's a success case. That means they're doing everything right, and they don't need a stranger in a black robe to help them with their lives. So my hope was that these kids, somebody would explain to these kids, it didn't work with deputies, it didn't work with the prosecutor, it hadn't worked with me, it hadn't worked with the guardian. Dr. Ludoff told them they could go to jail. Mom put that on the record in August of 2014, that my kids think they're going to be detained. Well, because they don't follow court orders. Like any person that doesn't follow a court order has the risk of being detained. So I'm thinking, if those 3 lawyers get to these children and can explain to them that they don't want to go down that road, that they would just, somebody would report to me, oh, they're having parenting time and it's great. And I wouldn't see them ever again. I wouldn't be a part of the parenting time in a jury room.
All right. And so you directed your staff to call down for the appointment of lawyers, is that right?
Yes.
Were you personally involved in the selection of these lawyers?
Not at all.
Okay. We heard from their testimony, right? Earlier.
Yes.
And did you actually know these are the lawyers who were involved?
On a professional level.
Understood. They appeared before you at least on one prior occasion.
Yes, yes.
Did you consider them all to be experienced and competent lawyers?
Yes.
And when you appointed the lawyers for the children, did you set any time limits on them in terms of how long they could spend with their clients before you were going to go forward with the hearing?
Not at all.
Why not?
There weren't time limits. Like, I'm there all day, every day, all day. And everybody that's ever appeared in front of me knows I say that all the time. And I wanted it to work. I didn't want to have a hearing. If they could have gotten through those children, they didn't need to walk into the courtroom. They just would have had parenting time.
And eventually you go forward and you have the hearing, right?
Yes.
And eventually you find each of the children in contempt, true?
Yes.
Looking back on that day, on June the 24th, particularly on the hearing day, do you have any regrets about appointing lawyers for the children and moving forward with a contempt hearing?
No,
Objection of relevance.
no, I don't have any, no.
And with regard to your comments, your statements on that day, if you had the opportunity to do it over again, would you do anything different?
I would not have informed the youngest, the middle child, that his older brother had picked Children's Village. I would not have done that, because once, in my opinion, once I did that, he went, oh, like he always did, and blindly followed him.
Anything else?
Using the Manson word that had been used before two times in a report, cult-like behavior in the same report, as well as in 2012, one of the therapists said that described their behavior as bizarre, dysfunctional, controlling, verbal and non-verbal, the ringleader, the enforcer, all of those things. Everybody in the court knew what that meant, that had anything to do with that 5-year custody case. And nobody else did. So it was a short phrase for a litany of behavior from those children.
Fair to say that on that day, based upon everything that had occurred for 4.5 or 5 years prior, and even on that very day, that very morning, you were maybe a bit frustrated?
I actually wasn't frustrated at all until I never for 1 minute thought that any person faced with door number 1, parenting time, and door number 2, Children's Village, that had been explained to them over and over again that this could happen, would pick door number 2. So it is still shocking to me that any child would want to go to Children's Village instead of having parenting time with a parent.
As we saw the tape, you described Children's Village in pretty stark and harsh terms, fair to say?
Absolutely.
What was your thinking behind doing that?
Children's Village, well, I'm a huge fan of the operators and the director and all the people that work there. It's still not your house. It's still not, you don't have the comforts of your home. Children's Village is what Children's Village is. And if I'm going to explain to children that door number 1 is parenting time, and door number 2 is brownies and going on field trips and going to the zoo, or quite frankly, cotton candy and roller coaster rides, which they don't do that, but they're never going to pick parenting time with their father if they think, oh, it'll be great over there. And as great as Mandy's place is compared to Children's Village, it's not the same as being home and being with your friends and being with your dog and being with your friends and your loved ones and watching TV when you want to watch TV. It's not, and no one could say it is.
Okay. As we saw in the videotape, during the course of the hearing, as you're talking a little bit about the Manson-like behavior that you're observing and what have you, as you're addressing, I think, the older children, you're making, at one point, a swirling gesture next to your head. You recall that?
I do.
And tell us, if you would, what you were thinking about at the time, if you know.
All right, I will tell you this. I got my 28-day letter from Mr. Fisher on September 3rd, a Thursday. I had just gotten back from lunch, and 2 of my staff members come in, and they say like something really silly to me, which they don't normally do. And I said, what is going on with you two? And they hand me the big, huge envelope, and I start going through it, and when I get to that allegation that I twirled my fingers, calling the child crazy and calling him Manson, I said, there's no way I did it. I have the original one, and I had actually wrote on it, no way. That's within probably 4 minutes of receiving it, because, you know, I don't even know what number that was, maybe like 63, so many allegations. And I said to my secretary, Ann, pull that up. So Ann's sitting in this chair, Amanda's
When you
sitting
say
in this
pull
chair.
that up, you mean pull up the video?
Pull up the video, because I don't call anyone crazy, I don't do that sign, it's just not something I do. I don't say the N-word, I don't say G-O-D, I don't give people the finger, I don't twirl that sign. There's no way I did that, is what I said in my head. So I go, Ann, go get it, go pull that up. So Ann walks, I can see from my chambers, we look at each other, and she pulls it up and she says, Judge, you did do it. I said, I did not do it. She goes, Judge, you did do it. I go, there's no way I did that, Ann. I go, let me see. And so I look at it and I'm like, there's no way I meant that. I'm looking at Dad, I'm going, like, my Dad's like in the back, sitting down. I'm like, Dad, when we move forward with therapy, I'm always about moving forward. I always wanted to move forward on this case. I want to move forward on all cases. So that was my immediate comment. And if I didn't say that and they bothered to interview my secretary or my research attorney, who heard both, and I said nothing, then they would have brought that allegation against me.
All right. So, to be clear, it was not your intent to signify that you thought the child was crazy.
No.
But I believe in both your 28-day letter and the answer, you indicated that you could understand how people viewing the video, just as your own staff did, could perhaps come to that conclusion, right?
Yeah, absolutely, and I apologized for that in my 28-day letter, and I know how some people think it looks like, but I looked at that video over and over again. My colleagues looked at it, my friends, even people that don't even like me looked at it, and anybody who knows me knows I don't do that. And there's not one person in my entire 48 years will be able to testify that I've ever done that. Not one person. And I would ask them to show one person that said I did it. Clearly I did it, something like that, looks like that. I have a pen in my hand, I'm talking with my hands that entire video. And I'm not directly at my temple, and I don't call children crazy. I don't make fun of children, and I don't make fun of litigants.
After you find each of the children in contempt, each of them is taken out of the courtroom in handcuffs, right?
Yes.
Okay. Did you have anything to do with how the children were taken away or secured after you found them in contempt?
No.
Okay. Have you ever in the past had children taken from your courtroom in handcuffs?
Yes.
Okay. And that, I think, as we heard from the testimony of Deputy Maloney, to the best of your knowledge, is a policy of the Oakland County Sheriff's Department, right?
It's been the policy. I've been in that courtroom one way or another every day since 1995 when I was promoted to circuit court. So I practiced in front of every single judge in that building.
1995 when you were an assistant prosecutor.
When I was promoted to the felony work.
All right. There came a point in time, did there not, on July the 10th, when you had everyone back to talk about the children's contempt?
Yes.
Okay. And on July the 10th, by that time, had you gotten any communication that the children had changed their minds, that they were willing to purge their contempt, that they were willing to follow your orders?
No. I had heard that they were making progress, but I didn't know, I had not heard that they were willing to purge their contempt.
Okay. But you decided to have a hearing anyway, is that
Yes.
right? And why did you decide to have this hearing?
Mr. Lancet he asked to have an emergency hearing. I wanted to have a hearing. It wasn't ideal for those children to be in there, and I wanted to see if there were any alternatives that anybody could possibly have.
All right. So that was your purpose?
Yes.
You were simply responding to Mr. Lancet's request for emergency hearing?
Yes.
All right. Your Honor, I believe the videotape of that particular hearing was admitted. I'm not sure what exhibit it is of the petitioners, but ours, it's actually R88 and the transcript is R87. It's a relatively short hearing, and with the court's permission, I'd like to play that video, and that would be the end of my examination of Judge Gorcyca.
All right. Any objection, counsel?
It has already been admitted.
Well, no objection. I believe it's 87, 88, I believe,
That's correct.
and it's 88A, I think, is,
All right, I think much like the co-examiner's prior videotape, I think this one is in two parts, so we'll just play them back to back.
all right, thank you.
Simone versus Simone, case number 2009-766-749-TM.
Good morning, Your Honor. Carrie Middleton, on behalf of the defendant, Omar Simone.
Good afternoon, Your Honor. Lisa Stern.
Good afternoon, Your Honor. Michael Dean, P32631, court-appointed attorney for Roy Simone, and standing in today for the attorney of record, Karen Cook, for Natalie Simone.
Good afternoon, Your Honor. My name is Jeffrey Schwartz, P32076. I'm here as attorney for Liam Shoshone.
With Matt's at GA, everyone.
Good afternoon, everyone. You may be seated.
Mr. Can you hear us? Simone?
All right, sir, on the telephone, will you please state your name?
Yes, my name is Omar Simone.
And can you tell the court where you are right now?
I'm in Israel.
Right. I called the lawyers and the parties here today to address what is in the best interest of the children. We will not argue the motion for reconsideration that will be heard next Wednesday if it is necessary. The court has one objective today, to determine the best course of action for these children. As of today, not one lawyer for the parties has offered to the court, verbally or in legal pleadings, one solution or option other than Mandy's place. This is a family court where children are the highest priority. The principles that underlie family court cases is doing what is in the best interest of the children. I have personally dedicated my entire professional career to protecting the people and the children of Oakland County. This case has garnered national attention from the news media in the past couple of days. The hysteria surrounding this case has been caused by a local media outlet that broke the story without getting all of the facts straight. Most disturbingly, that media outlet has also released the names and faces of these children. That media outlet failed to exercise due diligence in their investigation by failing to get both sides of this case. They failed to obtain a history, a chronology of the events. They have failed to review court hearings and orders. There are 8 files. And no one has reviewed those files, and as of right now, no one has ever requested to watch any video. As a result, we have a frenzied, misinformed, and misguided public. It is a complete disservice to those who would want to be intelligently informed, but way more importantly to these children. It was not in these children's best interest to release their names or their faces. Any lawyer, judge, mental health professional, or caseworker who has any involvement in the family court is aware that one of the most devastating issues we face is that of parental alienation. The definition of alienation is to make hostile where previous friendship had existed. Experts have devoted considerable scholarship and research to this topic because it is one of the most difficult problems to address. Parents alienate their children from the other parent by aligning with them, sharing information which is often biased and untrue with the children for the sole purpose of having the child reject the other parent. The judicial system has very few tools to fix this problem, especially with adolescents who are taking positions based on the emotional burden placed on them by a parent. To say that they want to see one parent would place them in direct opposition to the other parent who has convinced them that that parent they want to see is the enemy. While this court's remedy in this particular situation may seem drastic and offensive, so too is the notion that children have been convinced that the only way to maintain a stable and loving connection with mother is to vilify and reject a father. The court agrees that placement in Mandy's place is not ideal. However, the court's primary concern is the best interest of these children. The decision was made so they could be put in a setting where they would not be emotionally manipulated and pressured to love one parent and hate the other, where they will receive counseling, support, and comfort in a safe place, where the message is that it's okay to love both their mother and their father. It was also a remedy the court took after 5 years of litigation and orders designed to foster a relationship with both parents. In the 5 years this case has been ongoing, the court has received no credible evidence that father has done anything to negatively affect the mental, physical, or emotional health of these children. In fact, this father has moved mountains to be able to be part of his children's lives. When the decision to temporarily place the children in Mandy's place was handed down, mother did not object. Mother's lawyer did not object. In fact, no lawyer objected. The guardian did not object. no one offered any alternative placement options. The first objection to the children's placement this court received was 2 days ago. Faced with too few options and a custody arrangement that has become increasingly harmful to the children's well-being, this court removed the children from mom's care. Despite the claims of recent media coverage, this action was not carried out as a punishment, but was instead implemented in an attempt to assist these children in developing meaningful relationships with their father. Placing these 3 children in Mandy's place was and is in their best interest. The children first came to this courthouse for a parenting time in August last year, after dozens of failed attempts at meaningful parenting time with their father outside of the courthouse. It took no less than 6 deputies, a prosecutor, various court personnel, a representative from the Department of Health and Human Services, my family counselor, and myself to finally convince the children to have parenting time with their father in my jury room. This court witnessed disturbing behavior from all 3 children that day. Once inside the jury room, they refused to interact with or even look at their father. The court met with the children several times that day in an effort to encourage them, but ultimately had to order them to see their father, which is well within the court's authority. The issues with parenting have been ongoing for the past 5 years, as have efforts to assist the family with therapeutic and supportive services. Father filed his motion for an order to show cause mother on March 23rd of this year as to all of mother's parenting time violations. Mother agreed following the filing of that motion to spend the day in detention and to spend additional time volunteering at an animal shelter. This court again witnessed disturbing behavior displayed by these children on June 24th. Following yet another failed attempt at meaningful parenting time with the father, the children's guardian ad litem, the parenting time coordinator, and the family counselor in the jury room, this court ordered the children to have lunch with their father and speak with them. Each child refused and indicated they would rather go to Children's Village than spend time interacting with their father. While it came under a contempt of court ruling, my intention was, and continues to be, for these 3 children to receive independent, objective, and caring counseling outside the influence of both parents. These 3 children are not being punished. They have been removed from a home situation in which they were unable to pursue a healthy relationship with their father. They have been evaluated by no less than 5 independent professionals in the past 5 years. This court appointed the guardian ad litem 5 years ago to assist with these children, to help their best interests be heard. Every alternate avenue presented to this court has been exhausted. This includes many parenting time supervisors, therapeutic parenting time in each parent's home, parenting time in public setting, and Skypes with the father. Each attempt has been met with resistance from the children, refusal to acknowledge the father, and complete disregard for the authority of the court. These children are unable to understand their need for healthy and productive relationships with both of their parents. Contrary to what has been reported, these children have not been locked up, and they are not placed with juvenile offenders. Rather, they are in Mandy's Place, a non-secure, safe environment on the grounds of Children's Village, where children from difficult circumstances receive outstanding residential, mental health care, and other services. Mandy's Place is for emergency placement for children who have no next of kin, no foster care designation, or need temporary placement. The children are able to participate in fun activities, including field trips, they attend school, and interact with other children. Mandy Place reports that in the few days they have been there, the children are interacting with other children, participating in fun activities. Their counselor indicates they are making progress. This is the first progress for these children in the duration of this 5-year-long divorce case, and the evidence that the decision to place them at Mandy's Place is serving its intended purpose. Mandy's Place has the resources to get these children on track. While it is clear that these parents are unable to effectively co-parent, the goal for these children is for them to develop healthy and sustainable relationships with both parents. Having such relationships would undoubtedly benefit them for the rest of their lives. No matter what animosity may exist between these parents, their first thought should always be about maintaining a healthy, loving, and stable environment for the kids. This includes supporting a relationship with the other parent. Until these parents are capable of doing so, this court will remain vigilant for the children's well-being and make every ruling in their best interest. So having said that, where is Ms. Kelsall here? Ms. Kelsall, if you could please approach the podium. Would you please state your name for the record?
Brittany Kelso.
Where do you work?
I work at Oakland County Children's Village, specifically Mandy's Place.
All right, and can you describe Mandy's Place to the court?
Mandy's Place is an open setting. It's a residential building where children, as you've already stated, come to stay because they have no other placement. Once they're there, they receive ongoing care in regards to some medical needs. They receive dental services, they receive recreational services, as well as mental health services. We also do several different options in regards to school. Currently, all three of the children are attending summer school through our Children's Village School, which is ran through Waterford Public Schools.
Right, can you tell me how often do you see the children?
I see the children nearly daily. They interact. They're doing very well. They're doing very well. They seem to be making progress on a daily measure. Each day they interact with their peers, they're laughing, they interact with the adult staff members, they're smiling. We have been working with them on a therapeutic level in therapy to, again, try and hone in on the relationship with the father. And so, again, it's going to be a slow, but hopefully steady progress. But right now, the children all three of them are stable. They seem to be enjoying their time with their peers as well as the other adults. They're enjoying things such as barbecues, going on nature hikes, doing an art program. And Your Honor, you arranged for the Canine Advocacy Program to come over because the children love animals. And so the kids really appreciated that, and I want to thank you from them that they enjoyed that.
Right, thank you very much. Very appreciate you informing the parties. Next, the attorney for the children and the guardian. If you could, has there been any progress?
Thank you, Your Honor. Michael Dean on behalf of Rory as well as Natalie. I did visit with the children yesterday. I will indicate, in my discussions with them, they basically stated that their needs are being met on a daily basis in terms of their health as well as their getting daily meals. That being said, Your Honor, I did meet with them right before we came out here, told them about today's proceedings, asked them in terms of their placement. They both indicated that they would like to return home to mother and that they still would not want to talk with their father at this time. They have no relationship with him. Thank you.
All right, Mr. Schwartz.
Good afternoon, Your Honor. Jeffrey Schwartz on behalf of Liam. I had a discussion with Liam. He as well had indicated that he's doing fine and he's being treated fine. He has indicated to me, well, actually, I had a long discussion with him about what my role was, and I indicated to him that I'm his advocate, and when I get the chance to, I would advocate for his release. He too wishes to go back with his mother. He indicates at this time that he still maintains his position concerning the relationship with his father, and that, at least at this point, has not changed. That's about all I can report at this point, Your Honor, but I will have continuing discussions with him. I think he expected, and the court has made it clear that you're not going to hear that motion today, so I'll let him know that, so he'll have some more time to think about his position, and then we'll go from there.
All right, thank you. Mr. Lansing, can you report on the progress or what has happened?
Well, I want to say to the court first that I've seen them every week. The one that I thought made a little bit of progress has been Liam in talking with me and understanding that he doesn't belong there, he shouldn't be there, neither one of them should be there. I've told them nobody wants them there. They should be starting school, they should be doing other things. Liam, I think, was a little more receptive. He appeared open to working with the court, maybe trying to see his father privately, trying to talk, trying to have some eye contact. He would try. We can't obviously move his mouth for him or tell him how to feel or tell him how to think, but he was a little more open to that. And based on that conversation on Wednesday, I told him I would call the court and see, I think it was Wednesday, call the court and see if I could bring this matter in sooner. I did, and the court set today. And I told that to Liam that I did that. I don't know if his position has been changed with his attorney. So, and by the way, Judge, we have been talking over the week and a half, 2 weeks, all of the attorneys to try to come up with some plans. So we have been doing that, and I will make that suggestion. I do want to say, Your Honor, that the court appointed me after there was a motion filed on a Wednesday 5 years ago in August by the father for unsupervised parenting time. You granted it, and then you appointed me, said try to jail, work out a plan. I didn't know much about the case. I know that mother was extremely upset at the time. She thought that the father was going to take the children to Israel, all this and all that, and she was very upset. And I said, well, go back in there with your attorney, work out something, maybe with passports and something like that. She did, but she was very, very emotional, very upset. The 4 days that he really maybe had 1 or 2 days of unsupervised parenting time. After that, I was on the phone Friday and Saturday, Thursday, Friday, and Saturday with either the police, protective services being called, the children calling 911, father reporting mother was sending neighbors there. And so eventually I had to tell the police, then you need to stop the parenting time and I have to get a supervisor in there. This isn't working. So it was sabotage. Now, after that, for 5 years, Judge, we have tried everything that mother has asked us to do. We have tried every form of supervisor, every form of therapist, every form of counselor, psychological evaluations, parent evaluations, $10,000 report, and tried to do what mother wanted us to do. We tried dogs in the car. We tried a year of a counselor in the home with mother and the father with the children. Every time mother has proposed something, we've tried to work with her. A neighbor friend of hers, we put the kids there. We've tried everything. For a period of time, mother never even appeared at court hearings until you told her she needed to come. Nothing worked. And it came to the point where I think it was a 30-page report where I basically said to the court, I laid it out. I said, we can't counsel this case. We can't therapy this case. The behaviors are very disturbing with the children. I firmly believe that mother believes that it is appropriate behavior of these children to react this way to adults and to the father. I think she sees there's no issue with it whatsoever and not a problem. She supports it. This is part of the problems with these kids. I think the damage is so severe. It's very sad. Very, very sad. A year ago, when we came before this court, and the court finally had a chance to see it, that when those kids were outside, you had no less than 6 deputies. Those children huddled together, tapping their feet, sending messages to themselves. They wouldn't even talk to a deputy with a gun. Mother did nothing. An hour went by, all these deputies. Your friend of the court counselor. The behaviors were frightening. It doesn't take a PhD to figure out that there's something wrong going on with these children as it relates to their father. But how children talk to you, talk to the family counselor, forget me, talk to sheriffs, unbelievable. And mother simply had no effect and was unfazed by it. You brought her in here twice, and you said, stop this, or you're going to go to jail. Didn't bother her. I think after that there was a motion hearing where you at that point in time said, I'm going to change custody, I'm doing it right now. You were prepared to do it. I said, no, I don't think that's what we should do with these kids. Maybe that was a mistake on my part, but I didn't think that was the right thing at that time. To your credit, you tried to fashion a remedy to try to help these children. You can debate whether it's legal, not legal, whether you can do it or not, fine. But what strikes me, Judge, is that there is nothing in mother's pleading to this court that would have said the following. I disagree with what the court did. I believe legally it was wrong, whatever. Having said that, I do not think that the children's behaviors are appropriate to adults, to their father or anyone else. Let's try to work this out. I don't see that anywhere. And by the way, with counseling, that has never worked because 1 or 2 times the kids with mother would take them, they won't even get out of the waiting room to get in to see the counselor. Mother argues to the court at one of these hearings that, oh, these kids are traumatized by their dad, they did this and that. And then in the same breath they say, but we don't want counseling, we don't want to address it. My concern is how are we going to try to foster a normal, healthy relationship as they grow older for adults? I agree. We're not going to be able to force these children, Judge, to talk, move their mouth, love their father, not love their father. They have thoughts. I understand that. I do not believe they belong in the children's village. The children shouldn't be in the children's village. So one particular plan here today, okay, has to involve taking them out of the village, but it does not involve the mother. They cannot go back to this mother. So you can either do one of two things. Send them to Camp Tamarack overnight for a couple of weeks. They can go to an overnight camp, be away from everybody for a period of time, which would probably be very good for them. And then there is a woman that we've identified that would come into town to try to do extensive reunification. That's one option. The other option is there's a day camp at the JCC they could go every day. They'd have to find a different place to stay. And we get them into intensive counseling on a daily basis. I'm not optimistic that counseling is going to work. It might work if mother is not involved. I have to say this, Judge, to mothers. I've not talked to anybody in this case. I don't know this lawyer that she's got in New York, and that's something that they'll have to deal with. And I don't talk to the media because it's very sensitive. I want a protective order that that mother is not to put these children on any social media. If you can get an order to remove their faces from the social media, that needs to be done. I think it's outrageous to have done that to these children. They don't need it. And all a mother could have done is come before this court and say, I disagree with everything you said, Judge, but having said that, their behaviors are untenable. Let's try to fix it. You're not going to hear that because she doesn't believe it. And as a matter of fact, Judge, I do think that the one time that the child was in father's apartment, we had a hearing about that. When you had her trained, I think he's an ex-police officer, that mother found 2 years ago for supervision. I think the story that the child said was so outrageous and so different than what was observed. It was unbelievable. And I believe that mother told the child what to say, and that was the story, so she could sabotage them ever going to fathers. You got to give mother credit. Whatever she did all these 5 years, she's been successful at it, and she's been on a campaign, and she's won to some extent, and she has damaged these children. And, you know, mother, God bless you, you've succeeded in that. So I think it's a travesty. I want them out of the village. They don't belong there. Come up with a plan. If not, Judge, you have authority to do something, but they really need to be out, and let's try to come up with something. But it cannot involve the mother at this time.
Right, Ms. Lewis, do you have an option?
Yes, Your Honor, I discussed my plan and actually have made extensive efforts to try to secure a better option for these kids. I have talked to Ms. Stone about it. I have been in contact with Mr. Lancet for days on end, frankly, even over my own vacation, trying to figure out something. It was my suggestion that the children perhaps go to Camp Tamarack. I'm reluctant to talk about it too much because, quite frankly, I don't want this to end up in the press because it does not serve their best interest to talk about where the kids might be placed or what have you. And I'll address that further in a moment. But I have talked to the officials, the Jewish Federation, and Tamarack to be able to get these kids in today, tomorrow. They're already in mid-session. I think I'm hoping that they will agree. I'm waiting for a call back, but I'm 99.9% sure this is the viable option for them if the court agrees. Time and again, I have discussed with my clients about filing a motion to change custody. That I can't have 3 kids that go back to my client to make all sorts of false allegations, run away, do what have you. That's not in their best interest. I will tell you that given the turn of events, we had sincerely hoped that this time at Mandy's place in shelter care would bring them around a bit. And while I think some progress has been made, 5 years of damage isn't going to be undone in 2 weeks. So I will indicate I am going to file a motion for change of custody forthwith, but quite frankly, given the flurry that has gone on in the last 2 weeks, the motions, the appeals that have been filed just hasn't been done yet. I am going to file it forthwith. In the meantime, on behalf of my client, I'm asking that you allow the kids to go to Camp Tamarack. This court entered an order on June 23rd and one even prior about a reunification program. I filed a motion in February and again in March to show cause mom for her umpteen violations that I am not going to belabor again, as I've already gone over them dozens of times in this courtroom. How she does not foster a relationship and how she does everything she can to meddle, obstruct, or ruin whatever love these children may have had for my client. This used to be a loving family. He lived with them. They loved him. And it's gone. It's gone. So, I am going to file that motion. And I am going to ask for my client to have sole legal and physical custody. But the truth of the matter is, they'll run away from him if you put them there right now. So, consistent with the court's order of June 23rd, I want them to go to a parental alienation program. We have been in contact with, when I say we, myself, Mr. Lancet, all sorts of various programs. One they were not accepted in. One, I think there's no opening, but there are a couple others where they come here to this state a team. Nothing has been secured, but I do know that there is some availability. And of course, I'd like to be in consultation with Ms. Stern on that, Mr. Lancet. But my hope is that perhaps they can go to Camp Tamarack, and from there immediately they can go right to a parental alienation program. Frankly, the good programs would require a workshop scenario where the children and my client would go, and then there is an aftercare program. My hope is in the meantime that the court would grant a hearing on my motion to change custody, and we will work out where the children go after that program and evidentiary hearing. I think it's the most viable plan that I could come up with, and talking to officials to try to work that out. In the meantime, I also want to ask the court for a protective order. I know Mr. Lancet received correspondence from a woman by the name of Jennifer Holt, who alleges herself to be a New York attorney. She's gone out to various media outlets representing that she represents the children, and she actually ordered in her correspondence that Mr. Lancet, Ms. Lean, Mr. Schwartz, and Ms. Cook could not speak to her clients. Well, I'll tell you something. My client is the joint legal custodian of these kids, and while he may not have physical custody, he has all sorts of authority with regard to medical decisions, educational decisions, religious decisions, and what lawyers are retained on his client, on his children's behalf. He never consented to this woman representing his lawyers. I don't know who this woman is. She has never spoken to me. She's just sending letters out forbidding these court-appointed lawyers to talking with her clients. It's disgusting. She's not licensed here in Michigan. I know nothing of a federal lawsuit. My client knows nothing of a federal lawsuit. If there's one filed, I want to know about it immediately. But I am asking that this court enter an order that Dr. Simone be precluded from retaining counsel or hiring any professional on the children's behalf without my client's consultation and consent. Likewise, I am so disturbed that any media outlet would put a photograph up of these children. I personally drafted a press release on behalf of my client and indicated, I'm not trying this case in the media, I'll try this case here before you, Your Honor. But I said, you do not have my client's permission to publish photographs on social media, put them on television, put them in newspapers. My client will not be able to go to dinner with his children in our community without being recognized. How is that in their best interest? It's disgusting. It's disgusting. I'm asking for a protective order, Your Honor.
Hey, counsel?
Your Honor. Your Honor, as to the issue of the New York attorney that obviously none of us have met, none of us know, that is a federal issue, and actually I don't believe that this court can enter any order as to her representation of the children. That issue does have to play out in a federal court. There is law on point that also says even prior, 1983 action does not have to be filed, but that one of two parents, you don't have to have consent from other parents, to have the other prior on behalf of minor children, an attorney for a 1983 action, because to do so would be to cut them off at the knees. So the reality is the federal law is very clear on it, and we don't need to argue in this courtroom this is not the proper jurisdiction. We understand that there are issues with it, that there are attorneys not in this courtroom, not in the state getting involved, but I don't believe that this is the forum that can or should make an order as to that issue. As to the rest of it, it's all properly before Your Honor today. I'm not quite sure. You started these proceedings by saying that we were not arguing on the motion for reconsideration, yet there's been all sorts of discussion from all the attorneys that they did not want the children in Mandy's place any longer, and that they were going to be taken out, if you would so order, removed from that facility and put into another location.
What is mother's?
Mother's position on that, again, is more of a legal issue, Your Honor, in that there's no custody case before this court. Neither party, since the date of the judgment of divorce, has filed a custody action in front of Your Honor, which means that the broad ability, the broad powers awarded to this court under the Custody Act do not apply. In fact, if you look at the Custody Act, as we all know quite well in this courtroom, it indicates that an action has to exist, either through this court through the filing of a custody act itself, or arisen incidentally from another action in the circuit court, which is typically, like as we know, a probate proceeding.
My question is very simple. What's her alternative?
Her alternative is not an alternative. Well, it's for the kids to come home to her. She does agree that this court did order a reunification program for the children. And that program, the reason they haven't started is because counsel prior to me, no one had found one that was available. And it seems like Counsel for Father has done an excellent job in finding a woman who can come to Michigan, be with the children and father for about 5 days and 4 nights, and it seems to be a viable and economically wise program for these children to get into immediately, or assuming that that woman is available. As far as placement, Your Honor, I don't believe that this court has any authority at this point to do anything other than to return the children to their mother. Again, there's no custody case pending so that we can put these children in the care and custody of a third party. This is not a foster care proceeding. We cannot put these children in foster care. And
Her alternative is to return home. Is that what you're saying?
Is for to be returned home.
Mr. Lansett, do you have anything else you'd like to say? What is your recommendation as the advocate for these children?
My recommendation is I would like to see these children out of Children's Village ASAP. I don't think they belong there, not in their best interest at this point in time. I don't think that they need to do that. We need to come up with a plan. I do think you have authority. They can get their petition in should father want to pursue it. I think you do have some emergency orders under the Child Custody Act. There is a dispute because the parties can't agree, so it is submitted to you. You have jurisdiction. So I think that I'd like to see them out. I would like to see them either go to Camp Tamarack. Today they have transportation. They can enjoy a couple weeks in Camp Tamarack. Or you get them out. They can go to the JCC every single day, but they cannot. They have to be removed from the mother for a period of time. I will tell you what was disturbing. When we were here 3 weeks ago, when Mother said to me, 2 weeks ago, when Mother said to me, can I go back there and see Roy with her attorney? I said, sure, I'll bring you back there. So she goes in there, and then I find out she's talking Hebrew to them. When nobody, Sugin didn't understand Hebrew. And so this is the stuff that she's communicating to these children and has ingrained into them that this is the most dangerous, violent man. Well, if these children have these issues, then you try to work it out therapeutically. You don't stop the therapeutic process, which has been the case over and over again here. Maybe therapy might work without Mother's involvement. I want them out. I want to come up with a plan. I do want them out.
Can I respond, Your Honor, to the legal argument? My client is the joint legal custodian. He's asking for his kids to go to camp. It's that simple. You can make the call. It's not a change of custody or anything else. That determination will be made in the coming weeks. But it's not a legal issue. I mean, my client is asking for permission for his kids to be allowed to go to camp. There's no problem there. You can make that call.
Your Honor, as to that, whether or not a child can go to camp is not a joint legal custody issue for the court. Those are major life decisions. Education, medical, that does not fall within the purview or under the parameters of a joint legal custody issue. The other issue would be is if they are going to Tamarack, and if it's at Dad's request, is Dad paying for that program? That program comes at a cost. These are issues that the court would have to decide then today.
All right, the court's going to take a brief recess.
All right.
All right, I think that's the end of it.
The first one. The second.
Was there a second part?
I think there is.
Court recall Simoni versus Simoni, case number 2009-766-749-DM.
Good morning, Carrie Middleditch on behalf of the defendant, or good afternoon, rather, Omer Simoni.
Good afternoon, Your Honor. Lisa Stern on behalf of the plaintiff in this case.
Good afternoon, Your Honor. Michael Dean, P32631, a court-appointed attorney for Roe Simone, and standing in today for the attorney of record, Karen Cook, for Natalie Simone.
Good afternoon, Your Honor. Jeffrey Schwartz, attorney for Liam Simone.
Freelance J.L. May we approach one moment, Your Honor?
Yes.
Thank you.
Yes, I'm here.
All right, sir, will you state your name again for the record, please?
Yeah, my name is Omar Simone, and I'm in Israel.
All right, thank you. The court is ready to rule. The court is summarily dismissing the contempt. The court agrees with the children's guardian's recommendation as to the best interest of the children. The court finds that it is in the children's best interest to grant fathers and the guardian ad litem's motion to allow the children to attend summer camp pursuant to the Custody Act, including 722.271E. Children's Village is to facilitate the transportation. Parents are allowed to visit pursuant to the camp's policy and procedure. Both parents must have the parenting time supervisor present, Mr. Gallagher. I see you here. Thank you for being here. Mother must provide all the children's necessities. Parents are to share the cost of the camp. The court preserves the issue of appropriate division. Both parents must take the children's images off all social media. Both parents may not allow their children's images to be published. This court is issuing a protective order that the media is not allowed to publish children's images in this case. The court is also ordering parental alienation counseling. The court orders the GAL to be the LGAL and to review the letters from the New York attorney and to issue a recommendation forthwith. The court is asking the media to respect the privacy of the children in the camp and to allow them to have as normal existence as possible. I'm setting it for review on July 20th at 9 a.m.
Point of clarification, Your Honor. First of all, I would assume then that if the contempt order is now vanquished, that the attorneys for the children are released.
Any objection?
No objection, Your Honor.
Okay.
No objection. Mr. Vincent?
Yeah, no problem. Your Honor, Mr. Gallagher speaks, he's going to have to travel wherever the camp is, whatever selected. Who is going to pay for it? I think he has an outstanding bill, which I thought that mother was supposed to pay before. We can clarify that. Who is to pay for his bill going forward if he's going to wherever the camp is selected?
It continues to be the same division as it was.
And
nothing has changed.
And just so the record is clear, Your Honor, because it had occurred to me in terms of our obligations as attorneys for the children, that the children actually did have a right to appeal the contempt order, which would have run out on Tuesday. So it was our intention to ask the court to appoint attorneys to protect their right to appeal, but obviously since the order has been canceled, that's no longer necessary. But I wanted to make the record clear that all the children's attorneys did plan on doing that today.
Thank you.
Thank you.
Mr. Vincent Ross.
Rather, I'd ask that
In the order that neither parent will discuss any aspects of this case with the minor children, and they are supervised, and that they only speak English. Because obviously Mr. Gallagher does own that's his language, and that should be in the order as well.
All right. While the parenting time supervisor is present, the language that must be used is English. And I missed the first.
While the one is present.
While the parenting time supervisor is present with the parents' visitation when they're visiting in camp. Mr. Gallagher, does that work for you? Thank you. What was the first thing, Mr. Vincent?
well, neither parent
Oh, right.
discuss any aspect of this case with the children.
Mom, Dad, can you abide by that? Dad?
Yes, I can. And I will.
Another thing, Your Honor, do you want the sessions, whatever the camp,
You want the sessions individually with each child? I think that probably might be better if we tried individually.
That makes sense.
Yes.
So I think we should, the expert, however the expert says they want to do it. right, that concludes this meeting.
Thank you, Dr. Ryan.
All rise. Please, and somebody else who can move the files.
Now we're done. So I'd have no further questions for Judge Gorcyca at this time. Thank you.
You want to proceed with the cross?
We have no questions.
All right. Thank you. Any further witnesses? Judge Gorcyca, you may step down.
Thank you.
Any further witnesses for the respondent?
No, we don't. Although we do have a couple of additional exhibits we've moved for their admission.
Okay. I have right now I have the exhibits 1 through 62. With the exclusion, as Ms. Rainier pointed out, there's 36, 37, 39 are emails. These are emails or just notes. 42, 46, 47, 51. All the rest are court orders and are part of the court file. Those items I just indicated in the 1 through 61, 62 are simply emails, which the examiner objected to. And we got 77, 78, 80, 82, 85, 86, 87 admitted. Are there further exhibits?
Just a couple, Your Honor. One is Exhibit 63, which again is an order. That's the order of July 10, 2015.
I don't see an objection to that. It'll be admitted.
And the last exhibit, Your Honor, would be Exhibit 114, and that would be the amended statement of Michael Dean. I think that was referenced earlier.
Yeah, that was, all right. And you're permitted to move for the admission of the corporals of any document which is used to refresh recollection.
Yes.
Under 612. Counsel?
Your Honor, that exhibit was not provided until after the May 10th deadline.
I know, but you utilize it to refresh recollection in opposing counsel under Rule 612. If a document is used to refresh recollection, the opposing counsel may move for its admission on the Michigan Rules of Evidence, which are applicable to this particular proceeding. So Exhibit 114 will be admitted.
Your Honor, thank you. And again, I think the court just admitted, if I'm clear, Exhibits 87 and 88. That's the transcript and the video that we just saw. And they're similar to the exhibits that the examiner and co-examiner had.
No objections to that.
Right. Exhibits 87 and 88 were admitted. Obviously, we played them.
Yes.
The 88 is or 87 is obviously the transcript of what we just observed, which is Exhibit 88.
All right,
Anything further?
No, Your Honor. With that, we have no additional witnesses or evidence to offer, and the respondent will rest.
All right. Any rebuttal witnesses?
No, Your Honor.
Examiner rest?
Yes, Your Honor.
And then we will rest for about 10 minutes, all right? While you gather your thoughts, we'll 10 to 15 minutes.
All right.
We'll reconvene at 11 o'clock for closing.
Thank you, Your Honor.
Thank you.